Today I want to talk about the 13th Amendment, slavery in the Constitution before the Civil War. And one of the most interesting things about the 13th Amendment, which I'm sure we all know says that slavery is now unconstitutional, is that that was not the original 13th Amendment. The original 13th Amendment said something very different. This original 13th Amendment, known as the Corwin Amendment, named after its floor sponsor, Thomas Corwin from Ohio, was an attempt in 1861 to stop Southern secession. The original 13th Amendment, in fact, proposed that no amendment and no legislation could be passed regulating slavery in the states in which it existed. So every time you see the 13th Amendment, you should think about the original 13th Amendment. Even though we have the 13th Amendment, which abolished slavery, another interesting thing about slavery in the Constitution is that the term slavery is never mentioned until the 13th Amendment. It's never mentioned anywhere in the Constitution. So we have to infer from other clauses the existence of slavery and its protection in the Constitution. The first place that we see it is in Article 1, Section 2, what we call the enumeration clause. We know that our House membership in the House, is determined by population. The more population you have, the more representation you have in the House. During the Constitutional Convention, though, there was a lot of concern about simply equating population with representation in the House, especially because of slavery. Southern states and even northern states that had slavery, and by the time of the convention, most states in the North got rid of the institution, part of the revolutionary fervor. But in the South, where there was a lot of manumission, slavery started up again. We had a huge amount of overrepresentation, in a sense, in the South. And the Northerners were concerned that the South would be overrepresented in the House. The compromise that they developed, as we all know, is called the 3/5 compromise. And that is simply that every slave in the South would count as 3/5 of a person for the purpose of determining representation in the House. Again, the word slavery is not mentioned, but there's no question that the 3/5 clause was designed to apply to slaves. And then there's the slave trade, which is mentioned in two parts of the Constitution. In our lecture on the amendment process, I said there were two amendments that could never be passed, two unconstitutional amendments. One would have been to decrease equal representation in the Senate for states. The other one had to do with slavery, and that was that no amendment could be passed before 1808 abolishing the slave trade. That is also prohibited. Congress was also prohibited from making any legislation that would prohibit or hinder the slave trade until 1808. So there's two more places in the Constitution that deal with slavery without mentioning the word slavery at all. And finally, and the most controversial one in terms of real on-the-ground politics that played out before the Civil War, is what we refer to as the Fugitive Slave Clause in Article 4. And that prohibited states from refusing to serve up or return to other states fugitives from law. And a slave would, by definition, be a fugitive from law if he or she escaped the plantation and headed to a free state. And Article 4 required governors of states to return to the state from which they absconded fugitives, most particularly slaves. And I want to talk a little bit about that Fugitive Slave Clause. The Fugitive Slave Clause, again, requires that any state governor that finds in its territory someone who's a fugitive from justice return them to the state from which they absconded. Really motivated a lot of politics, a lot of political development in the antebellum period in the United States. Many of what we call the great compromises in American politics before the Civil War were great compromises because they really did prevent the Civil War from happening much earlier in American political development. And in the great compromises of the first half of the 19th century in the United States, there was always some kind of language about this article, the Fugitive Slave Clause. Again, not mentioning slaves, this clause, but everybody knew exactly what it was about. For example, northern states routinely ignored this clause, routinely ignored it. A slave would abscond from the plantation in Georgia, find his or her way to the north, say a state like Wisconsin, which had a huge anti-slavery component present in its state, and they would hide them. Fugitive slave catchers, these were people who made their business hunting men and women and children who snuck off the plantation in the South, would come into these northern free states, and they were privateers, they were private people, and kidnap, in a sense, the families or the individuals who absconded. This angered northern states tremendously. Many of them passed anti-kidnapping laws to try to prevent this. But the South, because of its overrepresentation in the House, because of the 3/5 clause, and because of that, its overrepresentation in the Electoral College, was able to pass federal legislation that a few times in the early 19th century sought to buttress and make stronger the Fugitive Slave Clause of Article 4. In fact, we have to understand the Fugitive Slave Clause requires governors, it requires the states themselves to return fugitive slaves. Well, what happens when they don't, the South said. Look at what's happening in Wisconsin and Pennsylvania and Massachusetts. These states are refusing to give us our property back, our slaves back. Well, after 1850, Congress allowed and provided for federal marshals to aid in the recovery of fugitive slaves. Federal marshals to aid in the enforcement of Article 4. And in many ways, this led to the beginning of the Civil War. This really ingrained into northern minds how much power the South had in the national government because of the enumeration clause. Again, that would magnify Southern power in the House. It also magnified Southern power in the Electoral College. And we have to understand that but for two individuals before 1860, the South, every president was from the South. It's because of this overrepresentation that we got Southern presidents, and therefore presidents who would sign into law legislation from a Southern-dominated Congress that sought to buttress and enforce the Fugitive Slave Clause in particular. And leading up to the Civil War, there were many court cases involving federal marshals who were arrested by state governments for kidnapping fugitive slaves that were in their state territories. And in an interesting kind of about face, we had northern states in the late 1850s espousing the doctrine of states' rights, which just a few years later would be espoused by the South because of secession. And you can understand why northern states would be talking about states' rights as opposed to national rights, because the national government was dominated by Southern slave interests because of this overrepresentation. So while slavery is not mentioned in the Constitution until our second 13th Amendment, it's certainly present there, and it certainly spurred American political development in the 19th century in ways that still reverberate to today. Thank you.
Freedom 101 is made possible by generous support from Woody Young and the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.